Hello. It's unusual that nowadays some people come to court unprepared. Maybe not only nowadays, but it's not unusual. What is worse, though, is that people often come to court thinking that they are prepared, but in fact, they are not. In the sense that they did not prepare enough evidence, good evidence, but they think that they have it. And how does it come to? Often, many people think, that it's enough to bring up some logic, some common sense as an evidence to the judge. It's not unusual to hear that people are asking the judge, like, Mr. Justice or Judge, what else do you think it might be? Or how else do you think it might happen? Or what should I, and so forth. So basically, questions are brought to the judge's attention, to the court's attention, as an evidence. But the judge is not there to exploit his imagination or her imagination. The judge is not there to create hypotheses for you and to prove those hypotheses for you. It's for you, for us, who come to the judge for resolution, to make our case, to create it. So asking, like, what else could it be? That's not enough. Asking the judge to continue the line and to make some his own thought of it, well, sometimes it's possible, but sometimes this option is quite limited. Several articles of the Civil Code of Quebec, they treat so-called presumptions, which in our context might be better called assumptions. So technically, when we don't have enough facts to prove something directly, we can prove all the premises, we can prove like all the preliminary factual context and what else could lead to that conclusion, to that assumption. And then when it's only one step left and there is basically no other option, it might not be in any other way, there you could invite the court, the judge, to make such a presumption, such an assumption, but again, not in the form of a question, but more in a form of a statement that you submit to the judge, you submit to the court that this is how it was, this is how it worked. But again, such a presumption, such an assumption cannot be based on common sense and logic. It should be based on proven facts, on something that was otherwise directly and solidly proven before the court already. So like long logical deliberations, how might it be, how could it be, inviting the court to share your imagination about reality, that doesn't work. Even if you, your lawyer, we all around, we think that, yeah, that sounds good, that sounds great, still it's not proven. The presumption, such a presumption, can be taken into account only, as I told it already, when everything else is proven by like solid way, and only the last step is there, and that last step is like inevitable step. As you can see, the Civil Code says that only serious, precise, and concordant presumptions should be taken by the court in consideration. Recently, the Superior Court of Quebec again pronounced on that, particularly, specifically saying that a hypothesis, a speculation, a suspicion, a conjecture are not enough to make a presumption. So basically, if you don't bring to the judge anything but for your ideas, hypotheses, your speculations, your suspicions, and your conjectures, it means that you don't bring anything of value to the judge. This is the decision. And this is the whole paragraph, if you're interested to read it. And this is not just a recent idea of some judge of the Superior Court. The very same idea was supported by the Supreme Court of Canada, where the court again was warning the courts of lower instances from overuse or abuse, if you wish, of these these inferences, these conclusions, because in an ideal situation for the court, everything should be proven by the parties, and then the court should apply the law. But of course, in civil cases, as opposed to criminal cases, everything is decided on the so-called balance of probabilities, meaning that it's enough that the judge believes one party more than the other. Well, roughly. And of course, in such a situation, it's almost inevitable that some things are not really proven, and the parties want the judge, like, judge, believe me or believe me. But again, we're talking about testimonies. We're talking about something that those people who want the judge to believe them, they saw, they heard, or at least they pretend. But when it comes to opinions based on speculations and so forth, from that point, however convincing you sound to yourself or to your lawyer, it's not enough evidence. For example, like, let's say that you saw some bad word painted on your fence one morning, and you think that nobody else but your neighbor who hates you could do that. And if you bring this to the court, most probably you'll fail because it's not evidence. But if you can bring to the judge evidence, witnesses, for example, like camera recordings, showing, first of all, that at this point in time, this painting was not there, and at this point of time, this painting was there, and that in the meantime, there was nobody walking on the street, and that around that time, the neighbor was around that place, even though it's not visible that he did something. But if at the end you could present to the judge that in this time frame this painting appeared, and about this time nobody but your neighbor was in proximity to this fence, well, preferably with some means to do that, then at this point, when it's like, one step close to the conclusion, then you can invite the judge to make such an assumption, such a presumption. But still, your neighbor could bring up another story. As, for example, he was walking with his dog, as he does every morning at the time. And if your neighbor could bring his own proof, his own evidence to that fact, then again your invitation to make a conclusion that you wanted might fail, because again and again this presumption, this inference, this assumption is not equal to the fact. It's sort of a gap filler, and the less you rely on that, the stronger is your case. Thank you and have a nice day.